You know, a lot has been made about the violations of the Second Amendment to the New York State Act. And there have been a lot, many infringements. And we could talk about them all night. But what's even more insidious and potentially more damaging to the basic civil liberties of New Yorkers is what's contained in Section 20 of the New York State Act. It contained 54 different sections of the New York State Act, changing many, many different parts of the law. Section 20 added a new portion to the New York State Mental Health Law, Section 946. Just as no law enforcement professionals were consulted in the drafting and the passage of the New York State Act, no mental health professionals were consulted until well after the passage of the law. On May 31st, 2013, well over 3 months after the law was passed, the New York State Senate Mental Health Committee, chaired by New York State Senator David Carlucci, convened a hearing to get the reaction and advice of prominent mental health professionals. The report of this meeting is public record. You'll find the testimony illuminating. What's most astounding about this hearing is that even after hearing from the most prominent doctors and practitioners, absolutely nothing was done to change or undo the provisions of the New York State Act. I'm going to give you just a brief report here on the testimony presented at that meeting. New York State Mental Hygiene Section 946 requires that when a mental health professional, defined as a physician, a psychologist, a licensed clinical social worker, or a registered nurse, who is currently providing treatment services to a person, determines that that person is likely to engage in conduct that would cause or result in serious harm to self or others, they shall be reported to the Director of Community Services. That director then must agree or disagree with the report. If he or she agrees, then they report that person to the Division of Criminal Justice Services for the purposes of either suspending or revoking that person's gun permit. That sounds reasonable, right? Nobody wants crazy people running around with guns, obviously. But what happens when you craft a law regarding mental hygiene law without consulting the professionals who actually work in the field? It's the same thing that happens when you pass laws without consulting with the law enforcement officials. I want to relate to you just a few comments presented at that meeting from Jed Wollenbright, counsel to the New York State Conference of Local Mental Health Directors, who said it was a mistake to include the DCS, which is the Director of Community Services, to be responsible for this kind of screening. The local mental health offices are not set up or funded to carry out what is essentially a criminal justice responsibility. This reporting requirement interferes with the therapist relationship. It appears to criminalize people who are suffering from mental illness. Some DCSs are receiving reports that appear to be made by someone other than a mental health professional treating the patient. We believe such report is not appropriate. Based on a potential risk management standards, hospital administrators have begun recommending or requiring that all persons admitted to hospitals with a mental health diagnosis be reported under 946. For liability purposes, they have to report when in their own professional judgment it might not even be appropriate. This is simply not a good use of what are essentially mental health resources for criminal justice purposes. Section 946 is simply another unfunded mandate of growing and potentially disastrous magnitude. Some of the comments made by Dr. Glenn Martin, who is president of the New York State Psychiatric Association. All studies will show that you're much more likely, if you're mentally ill, to be a victim of violence than a perpetrator. People are not going to talk to us if they're worried that we're going to rat them out at a moment's notice. He also said nurses are not in the position where they can diagnose or treat or prescribe. We have filed an inquiry or complaint with the Office of Civil Rights because we believe, in fact, that this is not compliant with HIPAA. It is actually not compliant with HIPAA right now, from Dr. Glenn Martin. Carla Rabinowitz of the New York Association of Psychiatric Rehabilitation testified And among her statements, she said, "So you know about the horrific media coverage, the demonization, the criminalization in the minds of people of mental health recipients. We are more likely to be victims of crime by 12 times. And we face 5 times more likely than the general public to be murdered. There's not any studies that are showing, despite all the stigma, that we are more likely to be violent. And the stark truth is that the public doesn't need protection from people with mental health concerns. It's us who need protection from this outrageous mischaracterization and from the rush to enact laws that prove false solutions to appease public fears. There's a lot of hysteria going on, and that's how this law came to be." From Mary Beth Anderson, Project Director from the Urban Justice Mental Health Project. "One of the greater problems for some people to access treatment is paranoia about being included on some sort of government list. The SAFE Act increases that paranoia. By and large, people with mental illnesses that do commit crime do not commit violent crime. The violent crime that is committed is generally not gun crime. When guns are used, they are almost always illegally possessed. I just don't think there is enough of a connection between gun crime and mental illness," she said, "to justify this reporting, which so increases the discrimination against people with mental illness." The Senior Associate of Policy and Advocacy for the Coalition of Behavioral Health Agencies, Jason Lipman, testified, and among his statements were, "We believe that it not only stigmatizes people with mental illness and deters them from treatment, but it also is a violation of HIPAA." This is a recurring theme among the mental health professionals. "As you heard earlier, and because of that, it exposes practitioners to liability risk. The HIPAA law allows practitioners to report clients in the presence of imminent risk. The SAFE Act does not meet this standard. On behalf of the 130 not-for-profit coalition throughout New York City, Westchester, Rockland, and surrounding cities, we look forward with legislators to remove this troubling provision." Dr. Eric Nieblum, New York State Psychological Association, was quoted as saying, "It is also our consensus of opinion that the mental health reporting provisions of the SAFE Act are not acceptable as they are currently written." Ari Moma, a registered nurse from the New York State Nurses Association, said, "We have serious concerns regarding the provisions of the SAFE Act, specifically Section 946. There are 3 concerns the New York State Nurses Association has. The first and foremost is HIPAA. Your reporting provisions are not in compliance with federal standards. Number 2, that the requirement that all mental health registered nurses will be mandated reporters. It is not consistent with our scope of practice. It poses us, the registered nurses, to liability. And thirdly, the linking of gun control efforts with mental health stigmatizes mental illnesses, and we create barriers to treating for individuals who need it." Kimberly Williams, Director of the Center for Policy, Advocacy, and Education at the Mental Health Association of New York City, testified that the SAFE Act is unlikely to identify dangerous people who would not otherwise be reported, but rather instead discourage people from seeking help in the first place. And finally, Beth Harulis, who is a staff attorney with the New York Civil Liberties Union, said the mental health provisions of the New York SAFE Act rest on fundamental misapprehensions about the highly complex links between violence, mental illness, and gun control. New York's SAFE Act mandates the creation of an enormous database with no privacy protections. We have consulted with law enforcement professionals, police, corrections officers who may be deterred from seeking treatment for fear they not only may lose their firearms, but then they'll lose their jobs as well. And she went on to say, like many significant areas of recent legislation in New York State over the past few years, the SAFE Act was crafted behind closed doors by the governor's office and immediately signed into law by Governor Cuomo. This legislative process makes a mockery of the democratic principles of transparency, accountability, and public participation in government.
Amen.
They didn't hold a single hearing or ask a single one of these mental health practitioners or professionals their opinion about the law that they were passing until 3.5 months after they passed the law. And now it's over 1.5 years after this Senate testimony, when every single witness stood up and said that this law is bad for patients, it's bad for mental health professionals, it's bad for, it's bad. It doesn't work. It's not going to identify anybody who's going to be a threat. So in closing, I just want to report what the attorney for the New York State Civil Liberties Union said, because I can't say it any better myself. Like many significant areas of recent legislation in New York State over the past few years, the SAFE Act was crafted behind closed doors by the governor's office and immediately signed into law by Governor Cuomo. This legislation process makes a mockery of the democratic principles of transparency, accountability, and public participation in government. Thank you.